And what we used to do in the old days, post-constitution, but the law has developed quite a bit, is we get an interdict to protect that property. We get an interdict that would allow the sheriff of the court to prevent construction of shacks, to demolish any shacks that are put up. Then, though, a few years ago in Cape Town, you'll know on the N2 in from the airport, there's a lot of informal shacks. The city of Cape Town got into trouble for evicting people using an interdict, and people went to court and stopped them from so doing. And basically, the theory is the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act, known as PI, is designed to protect people from eviction from their home without a court order. Now, the key point is home. My own view, and it hasn't been tested, but we've said this to the courts scores of times, is that if you are forcibly occupying a piece of land and there are thunder flashes and tear gas and all kinds of action, and you manage to get a roof up and throw a sleeping bag on the ground and jump on the sleeping bag, you cannot in good conscience claim that as your home. There has to be an element of permanence, an element of it having been established as your home. Now, that particular point hasn't had to be dealt with, in an opposed application, but literally scores and scores of courts have read that without demur and accepted that point. How it works in that rather unusual environment that shouldn't impact on our friends and colleagues on this platform is you have to respond quickly. So, and Bruno will get to the solution with the Airbnb, but so if you arrive home and someone's putting up a shack on your front lawn, you're entitled in hot pursuit to stop them, physically stop them and prevent them. I interpret my interdict, and again, many judges have never demurred on this point. I interpret my interdict to mean that if someone invades a piece of land and you respond quickly, a few days maximum, no one can claim it's their land because basically you are still in hot pursuit. So this is how the law is developed. The courts, the system, the Constitution looks to protect people who have a degree of permanence, whose home it is. And on that bombshell, I'll leave it to Bruno to explain what one should do if you are the Airbnb owner.
Just out of interest, before I get to that, what about the counter-spoliation approaches that they've been using where they don't even go for an interdict? They simply rely on immediate physical action to block someone from residing or making up some form of residence.
Yes, you can do that and should do that if you have the resources to do it. So, if you find some person putting up a shack on your front lawn, you can respond. You can get your neighbors, you can get your security company, you can get the cops. You can counter-spoliate then and there. Now, you'll recall that during lockdown, again in Cape Town, the naked man issue, that's what the city of Cape Town was doing. These were freshly built shacks. They had just gone up. And they were responding, they were counter-spoliating as they were entitled to do. And in my view, wrongly, the Cape Town High Court found that they couldn't do this. And I'd be pretty surprised if that survives appeal, because this guy had been in occupation for a very short time, if I understand it correctly. So what you saw, forget about Cape Town where there seems to be a concerted effort to attack this very element of the law, because I think these guys that we're talking about, Marley, that you mentioned, it's part of a concerted effort. You'll remember in and around Joburg throughout lockdown, there was a lot of there was a lot of stuff on TV about this very thing happening, and it's I mean, you know, if there's a piece of publicly owned open land or privately owned open land, and people start demarcating it to put shacks up, the authorities must respond. They must be entitled to do so, because the system depends on prompt response. You know, you can't always rush into court. One doesn't always have the time. You can put up a shack in under a day, and you can occupy it in under a day. And ideally, you don't want somebody in occupation of that shack to avoid the question that we're busy talking about. So counter-spoliation is real. Counter-spoliation is legitimate. And any attempts to close down counter-spoliation are wrong, anti-constitutional, and must fail. So, you know, I mean, I have a very strong view. I've been fighting this fight since 1995. In my first year of admission, I started having these fights. So this is something that I've been doing for a long time. And without that capacity, we're into anarchy. So I do believe that Cape Town judgment should and must be overturned, because you have to be able to counter-spoliate. Otherwise, the forces of anarchy will succeed, and they can't be allowed to succeed.
No, absolutely. So
but the test is it someone's home? If you're busy fighting and dodging the police and you got the whiff of tear gas in your nostrils, sorry, there's no permanence of occupation there.
Absolutely. So on that note, and the reason I specifically asked about counter-spoliation is because part of this question then goes into, again, taking the law into your own hands and starting to lock the people out. And my concern with that portion of the question is, in your examples, in your instances, you're looking at public land where no permission at all was given to persons to move onto the property. So at no stage was their occupation or their possession, even as it were, lawful in any way. Unfortunately, in a case like this with the Airbnb unit, the problem is for the first 2 days, if I understand from the article properly, they made payment. So they were in possession, they were in occupation, if you want to put it like that, lawfully for the first 2 days. So the ability of an owner to then go and simply lock them out in those instances, I feel would in itself constitute an act of spoliation. And you wouldn't be allowed to do that. So just a heads up, it is very different to the conversation we were having now as to, land invasion. It almost seems like land invasion. The problem is it was lawful at a given point. Now, to now touch on, basically take it all to, put it all together. So the interesting thing here, though, is touching on what Greg was mentioning regarding the permanency of the occupation and the actual residence. The provisions of PI, which is the legislation in South Africa that deals with evictions, it makes provision, again, for a degree of permanency. Airbnb and short-term rentals don't provide that degree of permanency. The problem is there's no set definition. We don't have case law. We don't have legislation that says permanent is 2 weeks or more, or a month or more, 6 months or more. So we can really only go by the facts of each case, and hopefully at some point we'll have a court that interprets this for us. So we've, for example, already looked at, and this is obviously just, Silna and I believe, had this conversation where we looked at the Rental Housing Act. And so, well, if 1 month and more than a month is considered to be long-term for the sake of that specific act and the CPA, you know what, maybe anything less than a month could actually be considered short-term. Anything more than a month would be considered long-term. But that is, again, something that we just did, off the cuff based on our opinion. But again, on this Airbnb, the guys booked 2 days, short-term rental, 2 days. They did not intend to make this their home. This means that, in my mind, you could get them out without relying on PI. So now the next point that I need to make is, what is the difference? Because people are basically going to be looking at me going, yeah, but you're saying I still need to go to court to kick them out. Yes, you do need to go to court to kick them out. But remember, PI has a lot of circumstances or considerations and requirements that you need to abide by. It's even got a slightly longer process, and its application in general takes a couple of weeks longer. If you actually approach court by way of a normal application, without using Pi, you can actually do the eviction a lot faster. So this is something to consider. The fact is you can go to court, you can get these people out without relying on the provisions of Pi. So that's a plus and something definitely to consider. Also, again, remember, if there's any fear at all, because also remember with Airbnb, naturally, you do have a lot of things on the property. And if I understand correctly, like this property, for example, is somewhere around 24,000 Rand a night, if I'm not mistaken. You do have things on the property that are very valuable. And if people have now said that their only intention for being on the property is to prove a point, and for everyone to realize they had no intention of staying there, they weren't acting with any sort of bona fide, I actually feel that you might be able to approach court or find a way of approaching court on an urgent basis if you do fear that there's going to be damage to this 24,000 Rand a night unit. The courts at the moment aren't dealing very well with urgent applications, so I would be careful. But I think because we don't have to rely on Pi, there's a lot of benefits in cases like this, insofar as going to court and trying to get the people out.
Perfect.
Do you agree, Greg?
I agree completely. Let me say, in the context of your last comments, which are completely accurate, one can approach the magistrates' courts, most of the local magistrates' courts, on your own. They give you a form if you've been spoliated. They give you a form, and I must say I have a slight legal objection to the form because it almost takes you inevitably through a spoliation scenario. So if you've been spoliated, you can get that done at the magistrates' court very, very cheaply and inexpensively and relatively easily. Cheaply and easily, I mean to say. The problem is it's unlikely they are unlikely to grant this kind of spoliation order because it's going to be unusual. The magistrates are often quite conservative and they will regard it potentially as an eviction, which it's worth trying because it is so inexpensive and easy, but there is that extra layer of complexity in that it's a counter-spoliation, and there's every chance that a magistrate's court, in the relatively simple mechanism we're talking about that I've referred to with a form, etc., may interpret it as an eviction. I do want to mention another scenario that I've dealt with many times in the inner city is residential hotels. And we've had this fight time and time again where it is notionally an hotel, but it's basically permanent. It might as well be a block of flats. So, very distinct from the Airbnb or the conventional hotel scenario, where it's very clearly not someone's home. I've had to evict people from university reses. Same story. Is it someone's home? There's conflicting case law. I don't think it's someone's home. But it's, a hospital. Someone books into a hospital. Yeah. They've got nowhere else to go. They're better, but they have nowhere else to go. What do you do?
So
it's not their home.
I want to pose something to you very quickly, because my attitude here is, since they paid for 2 nights, they were given possession. They were at some stage in lawful possession, and it later became unlawful. But because their intention was actually to do this, it's not like they stayed 2 nights and then circumstances changed and they got stuck. So, like, for example, with the hospital, you might not have a choice. With student accommodation, you stay there during a term, and now all of a sudden you need to be kicked out, but you don't have a place to go. These guys from the outset acted mala fide. Would that not in itself actually say, hold on, wait, that is an act of spoliation, because your intention, yes, you paid for 2 nights, so you were entitled, but your intention was never just to stay there for 2 nights. It was to make a point. So there might be grounds to approach this entirely off a counter-spoliation basis based on...
No, I agree. And I mean, I think the intention was to dispossess, wasn't it? But you're right. It's very distinct from both the scenarios that I gave: university res, hospital, residential hotel, certainly, because a residential hotel is in effect someone's home. But I think I completely agree with your approach.
Even a normal Airbnb stay where people stay on, is different. I think this one, because there's an article that came out where they made a statement. Say for the statement, my advice would have been, listen, you need to go to court. But I think because the statement came out, I would probably advise these guys to try go to court on a spoliation, because the statement actually defines the intention.
Agreed. But, I do think that if you book into a hotel or an Airbnb, the intention of the transaction is hotel or B&B. It's not, I think it's theoretically possible. You could book into the Ritz for 5 years if you're willing to pay for it every day. And at a stage, you could say it's my home, and then PI would be triggered. But 2 days at an Airbnb, no chance.
Fair enough.
Okay, perfect. Thank you so much for that. It's very interesting. All right, then we did receive a question from one of our viewers regarding a digital signature on an OTP. Is it valid? Is it enforceable? Bruno, do you maybe want to take this one?
Before you ask Bruno, I phoned Bruno to ask him a very similar question yesterday. So Bruno, over to you, man.
So unfortunately not. There's, just to explain to all the viewers, remember, oral contracts, verbal contracts, they're binding. Everything is binding. We keep saying this over and over. But there are some agreements or some documents that have certain prerequisites before anyone would actually consider them to be binding. So just to give you an example, a suretyship agreement. There's specific legislation that governs how these agreements are supposed to be signed and the fact that they need to be in writing. And one such piece of legislation is the Alienation of Land Act when it comes to OTPs or deed of sale, whatever you want to call it. When it comes to the sale of immovable property, there's a whole bunch of requirements. And one of them is that it needs to be in writing and signed. And the way that the legislation is drafted and been interpreted, what this means is an actual physical signature, not an electronic signature. A lot of other contracts you'd get away with proper authorized signatures in terms of the legislation that deals with it. But unfortunately, this one contract for the sale of land has been interpreted as having to be in writing and signed by both parties, physically signed. So unfortunately, not yet. It's not yet.
All right, perfect.
The question I asked Bruno related to the digital storage of leases, which is something that we should probably end up doing a presentation on one of these days. Hey, Bruno.
That was also such an interesting question, because it raises a valid point. I mean, we say that leases don't need to be in writing, but unless the tenant asks for it, then you need to provide the tenant. Can a tenant sign for a lease digitally or via email? Absolutely, there's no problem with it. But I think one of the problems that we feared that we'd encounter was, if you just take a lease, you scan it, you put it up on the cloud, you throw the lease away, you lose your original. Because if he signed it by hand and you're now scanning it in, you're losing your original document. If everything gets done digitally, you've at least got, you can track it. So you've got a history of everything that happened, and you can track when the original signature actually took place, be it via email or whatever the case is. But if you sign on paper and you scan it, the problem there is if anyone disputes their signature, you don't have an original to go verify the person's signature. The court might even give you hassle, because the court sometimes expects original documents. So that, unfortunately, what we had suggested was, if you want to scan it and chuck it away, make sure that you scan it, send it to the tenant first, get him to confirm that is in fact the lease that he signed, and then at least you know that you've got a verified copy which you can store digitally before you throw the other one away. Otherwise, just do it digitally from the beginning.
Thanks, Bruno.
Yeah.
All right, perfect. And then the last one, which I want to discuss is construction mafia. So should the property owners be worried regarding this? Can you maybe just explain it first? What is it about?
Sure. No problem. Look, it's something that shouldn't bother an individual or a suburban dweller. Basically, the story goes as follows. About 18 months ago now, this tendency started in KZN where people would blockade a construction site, demand payment, either out and out extortion or we want jobs at an accelerated rate, and literally blockade the construction site until somebody acquiesced. Now, that is spread out of KZN all over, certainly into Gauteng, and it's now a relatively common problem at mostly, in my experience so far, open land building sites. Now, the legislation requires, where it's a public construction site, RDP housing, for example, legislation requires a 30% local labor participation. So firstly, that interpretation is put onto any construction site, as you can imagine. Secondly, the difficulty in monitoring that is quite profound, especially because those tasked with identifying local labor or local contractors, that process can be politicized or corrupted. So it's very awkward. So what we've found over the last year or so is mostly on Greenfield sites in the sort of periphery of town with large-scale constructions, people blockading, demanding jobs, demanding better prices for contracts, getting annoyed if they've been fired because they don't know how to do their job, and blockading. And we've had to take interdicts. We've even had to go as far as getting warrants of arrest, and we've even gone so far as actually arresting people. It's got so bad. There's been quite a bit on television about this, because it's got so bad that the president has established a special task team to deal with these, calling it a major economic crime, as it is. Because if you're building RDP housing, for example, the margins are low. You can't throw money at poor contractors, people who are bad at their job. You can't pay over and above the accepted rate, because it makes the project unsustainable. And obviously we have a massive imperative to deliver low-cost housing in large numbers. So it's a real problem. And since construction started again, and I think around about the 1st of June, we've had a big flash up of these problems on open land. I was told today of it happening in town, in an inner city construction in Hillbrow. I've heard of it happening in relatively suburban environments, but large-scale construction in Pretoria. I haven't heard of it happening happily on a domestic construction site in the suburbs. It's not impossible. So let's just warn everybody that it is theoretically possible. If it happens, there is a mechanism. Contact one of us. We'll point you in the right direction on the task force. We could, of course, take an interdict. Those have been effective, but it's a problem. And I think as the post-pandemic economic problems continue, we're probably going to see more of this. Just to be alert.
Absolutely. So just to supplement that, because we were chatting about it earlier today, the concern that I have is at exactly what you said. So Greenfield sites where there's some sort of development going up, and the problem is people that dabble in inner city buildings don't always necessarily, you can't tell exactly what the person's doing. So I have a lot of clients that come in to say, well, we're taking this commercial building that's now dilapidated, we're going to turn it into student accommodation. Remember, the people from the outside can't always tell what is happening, and some of the construction actually looks big. So greenfields are obvious because you can see something coming up from scratch going up. But the reality is, when you're looking at building renovations or restorations, you're also looking at rather big projects. And even projects from ground up, I get a lot of people that buy some of the older things in inner city and want to put up like a small block of flats. So it doesn't have to be a 10-story, but I've seen 3 stories go up, 4 stories go up. And remember, at these projects, we're on ground level, all look the same. And so since this mafia, if you want to call it, doesn't actually know what they're dealing with, they're going to identify these sites, a lot of it just by visual identifiers. So just be careful. If you do get something like that, try avoid an interaction scenario, try avoid extortion, rather actually deal with it head on. Otherwise, you may just open the door for I mean, for more trouble for yourself.
Quite right.
Okay, perfect. Thank you so much for clarifying that. Do you guys have any last thoughts or anything you want to discuss?
I had a sheriff, I hadn't even mentioned to Bruno yet, I had a sheriff, well, one of the main inner city sheriffs today tell me, no, absent a letter or confirmation from COGTA, he can't do an eviction, which is, of course, nonsense. So
we had
I've
the
done
same
several.
one.
I know, Marilee, you've done several. I know, Bruno, you've done several without any problems, without any issues, actual execution of eviction orders. So he's simply wrong. And I did him a letter and I explained to him what the regulations actually say. There's certainly no requirement for getting any authority from any third party. In fact, I suggested to him that even suggesting so was firstly false news and therefore a crime in terms of the disaster management regulations, but secondly, contemptuous of court.
Because we will
protect the courts.
I'm sure he loved hearing that.
Yeah,
I suspect he probably didn't. Although, no, well, I mean, I'm sure he's only too happy to do the eviction, but I thought I'd lay it on a little thick from my client's point of view. So I did.
Fair enough. I think now this isn't to come across as a criticism of the sheriff's board, but I do struggle sometimes with the fact that there's a lack of uniformity, especially when it comes to things like this. Like I get small little details because some areas are so specific that sheriffs deal with it in their way, and it's difficult to have a sheriff's board apply it outright. But the regulation is the regulation.
Yeah.
It's in plain English. I mean, anyone can read it. Yes, it does take a legal mind to figure out where the onus lies, what the court needs to consider. But if you have an order that says you're allowed to execute, that is plain as day. And it complies with the regulations, you should be able to go ahead with it. And I almost feel like, why would now excuses start coming up to say, oh, but now you need third-party authority? Why? Where does it say that? It's not ambiguous. It reads clear as day. Yeah, so it's a bit of a problem there. I would actually go so far as to say, listen, Sheriff's Board, this is big. Issue a directive that covers outright all sheriffs so they know exactly what they need to do. Evictions are allowed.
Yeah. No, look, I think you're right. Bruno, Marilee, do you know Jacques Tariqa, attorney? He was my de facto principal, and so I've known him for years. And he represents a lot of sheriffs, and I think occasionally the board itself. So maybe I'll have a word with him and ask him to just sort of try and facilitate some kind of uniformity. I was quite surprised by the approach of the sheriff today. I mean, it was a genuine belief that he had. I'm not criticizing him for it, but any suggestion that Mrs. Dlamini Zuma has got to give authority for my eviction in the face of a court, sorry,
no,
that's not going to happen.
I did speak to, so I'll shorten the task on that. I spoke to Jacques at a stage also in his capacity as representative of Johannesburg Attorney Association, also just some of the issues at court. So his attitude, would rightfully so, is give him the examples specifically. As soon as you give it to him, he's happy to take it on. So, whatever documents you have, pass it on, and he'll take it up and he'll give you an answer. He's always just been amazingly helpful.
No, he really is. I will do. Thank you. Thanks for that.
Yeah. But it's quite interesting. I also yesterday had the same thing as you, Greg, with one of the sheriff's officers. The first time I had a problem with one of my commercial matters where they just refused to actually proceed with a warrant of ejectment.
Were you able to convince them in the end?
So
no, you're also busy with the letter to them. I tried over the phone, but also going to proceed.
But did you say on the commercial matter?
Yes.
But that's even...
That's it's more strange. So I don't know. But it's the first time I had a problem now. So but let's see.
Now we had a problem, oh man, when was it? What month is it? September. We had a problem just after we went to level 2, I think. Was it then? But again, I spoke to Jacques. The sheriff was a client of his. He understood the logic. Jacques got the logic, explained to his client, did the eviction the next day. Everybody happy except the evictee. He was very, very unhappy.
Yeah, I can
You can't
imagine.
win them all, Greg. You can't win.
Can't keep everyone happy all the time, eh?
All right. But thank you so much, guys. I think that is about the time that we have this evening.
Thanks, Marley.
And thank you for joining me. And then have a lovely evening and a holiday tomorrow.
Awesome.
You too.
And if
And
Solna's
we give Sil
watching,
now our very best.
yeah,
Sorry.
no,
Yeah.
she's watching. I know she's watching.
Well, I think Marley's on her machine, so
Yeah.
she's not watching there. So happy birthday for the other day, Silna. And you know, we did behave ourselves absent your strict supervision. So there we are.
Yeah. All right.
Thanks, everybody.
Okay,
Cheers, thanks.
bye.